Okay, thank you. Ah, there he
Thank
is.
you.
Welcome.
Thank you. I was
All
a little
right.
worried there.
We were too. Anyway, we're ready to start when you are, sir.
Thank you, Your Honor. May it please the court. Good morning, Your Honors. I'm Dave Caldevilla, and I represent the appellant, Ms. McLawhorn, who is the plaintiff in the trial court. I'd like to reserve 5 minutes for rebuttal, please.
All right, sir, you've got it.
We contend that GEICO issued an insurance policy to Ms. McLawhorn without bodily injury coverage in violation of the notice statute, which is section 627.7276 of the Florida statutes. The notice statute requires insurance companies to give their insurers a written notice warning them that their policy does not comply with the financial responsibility laws found in Chapter 324.
Mr. Caldevilla, you guys aired this out pretty thoroughly in front of Judge Thomas on September the 3rd, 2020. I believe you were there at the time, actually.
Yes, sir.
Why is she wrong?
Thank you for giving me that opportunity. There's many reasons she's wrong. She basically concluded, as GEICO contends, that they didn't violate. Well, that we don't have a cause of action available when GEICO violates a statute that doesn't have a private cause of action. But we didn't bring a private cause of action under section 627.7276, Judge. Point one of our appeal involves our statutory claim for declaratory judgment under count 1 and our common law claim for breach of contract in count 4. The trial court refused to reach the merits of those two claims based on the theory that we're attempting to assert an unauthorized private cause of action pursuant to the notice statute. However, we're not attempting to bring any cause of action pursuant to the notice statute. We are asserting a statutory claim for declaratory relief and a common law claim for breach of contract, and each of those causes of action are well recognized and independently authorized.
You state in your brief that when taken to its logical conclusion that GEICO's argument within the notice statute is meaningless.
That's right.
Do you not think that the legislature has other methods which they've prescribed to deal with actors who do not follow the requirements of the statute when there's not a cause of action, a private cause of action stated?
Okay, so there may be other remedies for other ways to address this, but GEICO hasn't.
The statute's not meaningless.
No, I hope not. We want to give it meaning. It is GEICO.
You said that the notice statute is meaningless.
If GEICO's argument is correct, it's meaningless. It's meaningless in that they don't have to comply with it according to them. And if they don't comply with it,
that's why I was asking you. Aren't there other ways that regulatory bodies or other people can deal with an insurance company who doesn't follow the statutory requirements?
if
And
there
if
are
that's the case, how is it meaningless?
right, if there are such other entities out there like the Office of Insurance Regulation that can do something about it, GEICO hasn't identified it. But let's get back to my right.
There are statutes for which there is no civil remedy available. This isn't the only time this has ever come up. In fact, your opponent relies heavily on the QBE Shelfante case, and the same sort of issue is it involved there, was it not?
No, Judge. So I'll get right into the Shelfante, but let me finish answering Judge Stargell's question, if I may. Judge Stargell, let's say, I think what you're getting at is the Office of Insurance Regulation may have some rights here to do something about this. First of all, GEICO has not identified any such remedy that we could get. But even if that's true, that doesn't block me from coming into the court and representing my client on a statutory cause of action for declaratory relief. Section 86.111 of the Declaratory Judgment Act specifically says that the availability of an alternate cause of action or administrative remedy doesn't block declaratory judgment action. Section 120.73 of the Administrative Procedures Act says the same thing. It says nothing in this chapter that gives powers to state agencies blocks a circuit court's ability to give declaratory relief. Now, if I could turn to Judge Black's question about the Chalfante case, it's not the same, Judge. The Chalfante.
There was a declaratory claim involved in Chalfante as well, wasn't there?
Right, and it was not dismissed. It was actually decided. There were 4 counts in the Chalfante case, Judge. If you turn to page 544 of the Chalfante decision, the Supreme Court quotes from the 11th Circuit's decision. And it's in the middle of my page in the first column from the Westlaw decision. But it says, in the district court, Chalfante raised claims for declaratory judgment in count 1, breach of contract in count 2, breach of contract in count 3. And then here's the key one. Count 4 was violation of Florida statute section 627.701 4A. The district court dismissed only count 4, Judge Black, only count 4, which was this imaginary cause of action, which doesn't exist. Violation of section 627.701 is not a cause of action. Okay, that's what the Supreme Court said, right, that needs to be dismissed. They did not dismiss the declaratory judgment claim, went to trial. The breach of contract claims went to trial. The 3 other claims brought by the insured in that case all went to trial, were all decided, and then went up on appeal to the 11th Circuit. The 11th Circuit didn't know what to do. They said that, well, here's a list of 5 questions that there's no controlling precedent in Florida on. And so we're certifying these questions to the Florida Supreme Court. Now, if any of those questions had been decided by well-settled law, the Supreme Court could not accept jurisdiction over those questions. None of those questions, Judge Black, none of them were, hey, can somebody bring a deck action to construe this statute, this hurricane deductible statute? No, that wasn't one of the certified questions. Can anybody bring a breach of contract claim? Because the statutes that regulate insurance companies are all incorporated within a policy by reference. That is the law. And they didn't say, oh, no, you can't bring a breach of contract action. Why would they not say that? Well, because there's a well-settled body of law, including Villazon, which is cited, by the way, in the Chalfante case, not reversed in the Chalfante case, relied on in the Chalfante case. The Villazon case versus Prudential, the Foundation Health versus Westside EKG case, both Florida Supreme Court cases, which hold that just because there's no private right of action under a statute does not preclude a plaintiff from bringing a common law negligence claim based on the same allegations. The Westside case, the Foundation versus Westside, said the same thing, but with a common law breach of contract. That's what we're doing. There's other cases, even this court, Your Honor, Vogel versus Cornerstone Doctors Condo Association by this court, which is a post-Chalfante decision in 2020.
Isn't the difference in all of those cases that there's some other action besides just the failure to comply with the statutory notice? You know, in Chalfante, whether it's font type, styles, exact wording, those were all different. There were other actions. Your case involves strictly the non-compliance with these actions. And in Chalfante, I was looking for this language. I know in your brief, you say the Supreme Court didn't have the ability to rule on these questions, but they say an insured cannot bring a claim against an insurer for failure to comply with the language and type size requirements established by the section in that case. And then further, an insurer's failure to comply with the language and type size requirements established by that statute does not render a non-compliant hurricane deductible provision in an insurance policy void and unenforceable. Right.
In fact, that was a declaratory relief right there. They interpreted the statute and said, look, and by the way, Judge Stargell, In that case, the insurance company gave the notice required by the statute, except for it was the wrong font size and one word was different. Instead of using the word hurricane, the insurance company used the word windstorm, okay? And the court said, look, they gave the notice here. And Geico provided no notice that their policy didn't violate the Florida responsibility law, none. But back to Chalfante in your question.
Mr. Caldevilla, I just wanted to let you know you're at 15 minutes.
Oh, my goodness. All right, well, let me
know.
quickly add a couple of points here. There's a long line of cases, a long line, including this court, that says that just because a cause of action, a statute doesn't provide a cause of action, doesn't mean that there's not a cause of action to be brought. You just can't bring a cause of action saying violation of the notice statute. That is not a cause of action. A DEC action is a cause of action. In Chapter 86, it specifically says any person who's endowed under their rights under any contract or any statute, they can bring a cause of action for declaratory relief. We're being locked out of the courthouse in violation of Chapter 86. That is a violation not only of Chapter 86, the plain text of Chapter 86, it's a violation of the Florida Constitution's access to courts. Now, I'm not saying I'm ultimately going to win. Maybe if you say I have a cause of action, which I most certainly do, it's got to be remanded back to the trial court to decide, okay, let's interpret this statute. Let's tell Mr. Caldevilla whether there's any effect as a result of this, like in the Chalfante case. Remember, we're not complaining about the font size and just one word missing. We're complaining there's no statute. This is like driving through a railroad crossing where there's no signs. The statute says you have to have a sign. I don't bring a cause of action for violation of the railroad sign. No, I bring a lawsuit for negligence. I crashed into a train because you violated that statute. That was a duty that you violated, and that's negligence. In this case, we have breach of contract. We have breach of fiduciary duty. We have DEC actions. These are well-recognized causes of action, and we are allowed to bring them. I'm not saying I'm going to win yet. I think I will if you let me in the courthouse. We've been locked out of the courthouse in violation of the Florida Constitution, in violation of the DEC Act, the Declaratory Judgment Act, in violation of common law contract claims and breach of fiduciary duty claims. We stated a cause of action for fiduciary duty, alleged every element, and so you can't dismiss us at that point. You have to let it go forward. But if we fail to allege an element, then you've got to dismiss without prejudice to let us amend. We could have brought it as a negligence claim. When you violate a statute that imposes a duty, that gives rise to negligence per se. I'm going to save any other time that I have.
Well, you're good. You're good. My timer went off, but I don't think it was exactly right. So
Okay,
I think you actually made it to your 15 minutes. So you're good. All right, Ms. Sears, when you're ready.
Thank you very much, Your Honors. And may it please the court, I'm Leah Sears, and I represent Government Employees Insurance Company, otherwise known as GEICO. The essence of the disputed issue in this case is really straightforward and simple, and it's this. May an insured like Amber Ray McLawhorn bring a claim against an insurer like GEICO for non-compliance with the notice requirements of Florida's financial responsibility law, the so-called notice statute? And the answer to that question is likewise very simple and straightforward. The answer is no. Why? Because the Florida legislature did not provide a private right of action for non-compliance with the notice statute. Florida law has long recognized that a private right of action does not exist unless the Florida legislature provides one. And it is beyond dispute that the legislature did not provide one here. Instead, Your Honors, the Office of Insurance Regulation, the OIR, has the exclusive jurisdiction to enforce this statute. It can do so by investigating a non-compliant insurance company. It can impose a fine. It can suspend a driver's license, and it can even stop an insurer from doing business in the state to name just a few of the remedies that the agency has at its fingertips. Therefore, this court should not abide McLaughlin's search for ways to force GEICO to pay benefits that she knowingly rejected and for which she never, ever even paid premiums. Florida law does not give her the right to seek private redress in the courts when the decision to decline to create a private right of action has already been made legislatively. And labeling these claims as an attempt to seek declaratory relief or breach of contract damages simply doesn't change that result. Also, the trial court was correct in dismissing plaintiff's claim for breach of fiduciary duty. Florida law is likewise clear that there is no fiduciary duty in an arm's length purchase and sale of car insurance. And quite frankly, those are the undisputed facts in this case. Now, as you were discussing, or was being discussed, in 2012, the Florida Supreme Court considered a case involving an insurance notice statute that required an insurer to include in their policy a specific quoted statement with a particular size font. In the Chalfanti case, the insured made the same allegations that McLaughlin does here, that it could bring a private right of action and obtain a remedy against an insurer based upon the insurer's violation of a notice statute. The Florida Supreme Court flatly rejected that argument, opining that the determination of whether a statute provides a private right of action is based on the plain language of the statute, or whether such a right of action may otherwise be judicially implied through specific legislative intent and or the history of the statute. The court in Chalfanti concluded that because there was nothing in the text of the statute to deduce that the Florida legislature intended an insured to have such a right, insureds have no private right of action. Moreover, Your Honors, nothing in the legislative history even hinted that the legislature intended to create a private right of action.
Ms. Sears, am I oversimplifying this, or are we essentially being asked to declare coverage based on the violation of a notice statute?
No, you're not oversimplifying it, Your Honor. That's the key. It's just as simple and straightforward as that. And in fact, this holding was cited, Chalfanti and Judge Black, your assessment was recently followed as recently as July of this year in the 11th Circuit in the case of Condominium Association versus Rock Hill Insurance Company. We sent you a supplemental authority.
Yes, I received that yesterday. I was going to ask you to, I think at page 15 through 17, there's a discussion of Chalfanti, and I wanted to get your take on why you think this 11th Circuit case reinforces your position in this.
Okay, this is what the case says, Your Honors. And I'm just going to read from it. It's the last, I thought this was the best part of the case. It says, it's very similar to this, to Chalfanti. It's very similar to McLaughlin. And this is what Judge Martin ends up saying, Beverly Martin ends up saying, quote, voiding an exclusion to insurance coverage is a severe penalty that alters the terms of the party's deal. It requires the insurer to provide coverage for uncontracted for risk, coverage for which the insured has not paid. Consequently, without indication from the Florida legislature that violating the financial responsibility law voids the offending deductible provision, in that case, it was another hurricane deductible case, we will not impose such a penalty here. Now, the Supreme Court in Chalfanti noted that the legislature expressly provided causes of action for violations in a number of other sections of the insurance code. Such sections explicitly state that a violation of the statute renders the policy provision invalid or void, specifically says that. And still other sections, the legislature crafted specific remedies for an insurance policy's non-compliance with the statutory requirement. This is all in the Chalfante case. In other instances, the legislature has provided that the Department of Insurance can levy a fine as a penalty for non-compliance. It is therefore clear that in the absence of an express penalty, courts should assume that a policy provision is valid despite non-compliance with the insurance code. The legislature, the Florida legislature, your honors, is perfectly capable of crafting an express private cause of action or any other penalty or remedy if it chooses to do so. As such, the Chalfante court opined that it could not provide a remedy when the legislature has either failed or declined to do so. The Chalfante court went on to say that when a statute merely provides for securing the safety or welfare of the public, it will also not be construed as establishing civil liability. This case, Chalfante, is effectively similar to our case. All right, my picture fell. Sorry about that. We just moved, so I can't guarantee the artwork here. Anyway, here too, the notice statute does not provide a private right of action to an insured for an alleged violation. Moreover, nothing in the legislative history amounts to a judicial implication of a private right of action. Instead, the notice statute merely requires notice be made in a specified format when a policy does not contain coverage for both bodily injury and property damage. As such, the statute merely seeks to secure the safety and the welfare of the public. It therefore should not be construed as establishing civil liability. Furthermore, McLaughlin can't disguise her claims as something than what they flat are. Claims almost entirely stemming from GEICO's alleged violation of the notice statute. In count one, the DEC action, McLaughlin alleges that GEICO failed to provide the notice requirement in the policy. Therefore, issuing a policy that violated that statute is contrary to public policy. And in count four, that's the contract action or claims for policy benefits. That count alleges that because GEICO violated the notice statute, GEICO improperly refused to provide bodily injury benefits to which the plaintiff claims she's entitled. There is nothing more in any of this than an attempt by McLaughlin to repackage her claims into either a DEC action or one for breach of contract, hoping that she can skirt by incognito. Now, McLaughlin also attempts to avoid the limitation on her ability to sue for alleged statutory violations by citing a bunch of pre-Chalfante cases, including two cases from the 1980s that she filed as supplemental authority this past Saturday. Those cases expressed a prior minority position that insurance code requirements may be incorporated into insurance contracts where the terms are essential. However, even the Chalfante cases, pre-Chalfante cases, limited that holding to statutory responsibilities that play an integral role in defining the party's rights as well as the party's responsibilities. The older doctrine did not apply otherwise to establish civil liability pursuant to an insurance statute like in this case, where the law merely provides for securing the safety or welfare of the public, which is what all the financial responsibility laws in all 50 states of the United States do. Further to this point, Your Honors, if this court were to conclude that the notice statute in this case served an integral role, then virtually all of the statutes and all of the regulations in the Florida Insurance Code would be deemed incorporated into insurance policies as a means for insureds to bring claims against insurers, regardless of whether the legislature ever intended that to be the result. Such a broad application would render Chalfante entirely meaningless and would reach an absurd result. Lastly, GEICO did not owe a fiduciary duty to McLaughlin. The undisputed facts here are that McLaughlin and GEICO entered into an arm's length transaction. You had a willing buyer and a willing seller. That kind of an arrangement creates no fiduciary duty on the part of GEICO as a matter of law under Florida law. That is to say it again. Because the undisputed facts in this case are that McLaughlin merely solicited coverage from GEICO, and GEICO simply provided coverage options and prices from which McLaughlin selected and purchased a policy. GEICO was not McLaughlin's fiduciary. In sum, this court should not create a private right of action where the legislature has declined to do so. Here we have a statute the legislature has given the Office of Insurance Regulation exclusive jurisdiction to enforce. Taking that exclusive authority out of the hands of the agency and effectively privatizing a citizen to do so is contrary to Florida law. I ask this court to please affirm the lower court's summary judgment and motion to dismiss orders for the reasons I've given here this morning, as well as all of the others that are in our briefs. Thank you very much, Your Honors, for your time and attention this morning.
Thank you.
Thank you.
All right, Mr. Caldevilla, your rebuttal.
Thank you, Your Honor. How much time do I have?
You've got 5 minutes. I don't know why my timer went off early, but it did. So
Okay,
you've
thank you.
got your 5 minutes.
Thank you. May it please the court. Judge Black, let me answer your question. You asked whether we're basically asking you to declare coverage in this case. And counsel said, yes, that's what we're doing. Nowhere have we ever asked you to reach the merits of this decision, of this case. We are not at the merits yet. We are not in the courthouse. We are being barred from the courthouse. We're being told that we're not allowed to bring a deck action when section 86.021 expressly states, Judge, the legislature knows how to create a cause of action. Here's what it says. Any person claiming to be interested in or who may be in doubt about his or her rights under a contract or whose rights, status, or other equitable or legal relations are affected by a statute may have determined any question of construction or validity arising under that statute, contract, or any part thereof, and obtain a declaration of rights, status, or other equitable or legal relations thereunder. We haven't gotten there yet. We're being told we don't have the right to invoke that statute, Judge, and we do have that right. We have the absolute right to invoke it. Now, am I going to win on the merits? I hope so, but I gotta be able to argue that. Counsel says, oh, well, the OIR gives you all these remedies. This is the first time they've ever argued that, by the way. It's not in their briefs. This is the first time we hear it. They don't cite any statutes, but let's say the OIR does have some rights to do something about this. I'm glad of it, but that doesn't stop me from bringing a deck action to understand what my rights are under a statute or under a contract. Chapter 86 specifically says it. It's expressed. We have to follow the statute. 86.111 specifically says the availability of any other administrative remedies does not stop a deck action. The Administrative Procedure Act, which governs the OIR and gives them any authority that they might have to pursue relief against GEICO, specifically says in section 120.73 that does not stop the courts from issuing declaratory relief under Chapter 86. So we have, counsel says, oh, the legislature knows how to create a cause of action when they want to. They did. It's called declaratory judgment action. I am allowed to bring a declaratory judgment action whenever I'm confused about what my rights are under a statute and under a contract. And I'm not asking you to rule on the merits today on any of these claims. Counsel says, oh, we don't have a fiduciary duty. Again, they're reaching the merits of the claim that was dismissed without giving us an opportunity to amend, even though we've alleged all the allegations, all the elements of a fiduciary duty claim. GEICO's just denying that they have a duty. Well, you don't get to do that at a motion to dismiss. Everybody knows that when you come in on a motion to dismiss, you have to admit the allegations of the complaint. They came in saying, well, we don't know a fiduciary duty. Well, they're just denying our allegations. That has to go forward. But if we missed an allegation, if we should have alleged something that we didn't, we have to have the opportunity to allege that without prejudice. That's what the law is. Counsel says, oh, we're relying on old case law. No, we're not. I've cited a dozen cases, some after Chalfant, some before, all holding that just because a statute does not provide a private cause of action does not mean that I can't go under an existing cause of action. There's more than one way to skin a cat. I'm allowed to try to bring a statutory cause of action for declaratory relief. I have a common law right of breach of contract. I don't have a cause of action called violation of the notice statute. There's no cause of action for that. And I haven't tried to bring one. I'm bringing what's allowed by law. Now, counsel says, well, this is an arm's length negotiation and my client knew what she was getting. No, that's not so. Let's look at please write this down, page 998 of the record, my client's deposition, where she explains what happened when she bought this insurance policy. They told her that she didn't need to have bodily injury, but what's important is she did not know what bodily injury cover is. She testified at page 998 that she thought bodily injury coverage was to protect herself, which we as lawyers, we know that's PIP coverage. We know that's coverage. It's not BI coverage. BI coverage protects third parties. She didn't even know what it was they were talking about. And they certainly never told her, never, that if she bought this policy, she would not be complying with the financial responsibility laws. And that's what the legislature wants insurance companies to do. They want people to be aware that there are repercussions if they buy this cheap cut rate, anemic insurance.
Mr. Caldavia, this
Yes,
time my timer is correct and your time is up. So thank you very
Right.
much.
For these reasons, I respectfully request the court to reverse and remand for further proceedings. Thank you very much, Judge Kelly. Thank you, Your Honors, for your attention and your time. Thank you.